I'd like to welcome in now Richard Schoenstein, trial lawyer and legal analyst. Richard, thank you so much for your time on this breaking news. I do want to talk about the civil trial. I want to get into more of the specifics. But first, does this come as a surprise at all to you, considering all of the questions, all of the notes from the jury to the judge? It was, Rich said it may have been as many as 11. And then we also know that the judge dismissed that more serious charge of second-degree manslaughter. So is this in any way a surprise?
It's a little surprising to me just based on what happened on Friday. Remember, the reason the judge dismissed manslaughter is because the jury was hung on that charge, meaning that some of the jurors wanted to convict and some didn't. And the prosecution said, well, let's just get rid of the charge because you needed a decision on it to go to the lesser offense of criminally negligent homicide. So the judge agreed to dismiss manslaughter. So because there were some jurors willing to convict on manslaughter, I'm a little surprised this morning that they acquitted on negligence. You would think if they thought that Daniel Penny had committed reckless, manslaughter, that he was also guilty of negligence. But I'm guessing, Nicole, that it was a small minority of jurors that wanted to convict him and that they simply gave up the fight over the weekend.
To expand upon that just a bit, Richard, again, we know that Penny was acquitted, but there was also this video evidence in the case, and there seemed to be quite a bit of video evidence. What do you think convinced the jury that he was not guilty of negligent homicide, which is what you maybe would have expected?
Well, I think it has to come down to intent. I know that the defense argued cause of death, and I didn't find that argument to be as strong as the other argument. I think it probably comes down to the jury deciding that the defendant didn't intend this result, that what he intended was to protect the train, protect his fellow passengers. And even if he was misguided in that regard, even if he used maybe a little too much force in that regard, they didn't want to hold him criminally accountable for his actions when they felt at its base he had good intentions.
All right, so let's talk about this civil suit. At the end of his reporting there, Rich McHugh made mention of it, said because of it, we may not hear from Daniel Penny himself. Do you think it's likely that we won't hear from him if his defense team does, in fact, come out? And do you think that this civil case will have a different outcome because we know the burden of proof is very different in a civil suit?
Right. Well, if I was his attorney, I would advise him not to comment publicly at all as long as that civil suit was pending, except possibly just to thank the jury and to, express appreciation for justice having been done, assuming that's his position. But I certainly wouldn't let him talk about any of the allegations or any of the specifics in advance of a civil trial. That case goes forward. It is a different burden of proof. They only need a preponderance of the evidence. They don't need beyond the reasonable doubt. And you don't need a unanimous jury in most civil trials. So that is different as well. So that can still go forward. The family can still seek to get something in their favor in the courts against Daniel Penny, and he would be well advised to let his attorneys do the talking in the interim.
And Richard, we know that this has certainly been a highly emotional case. That was evident in what we heard there from, Neely's supporters, the supporters of Neely's family. What do you think happens next as far as the city of New York is concerned, potentially spread out from there? Because we did hear calls for, people to meet up, to make their voices heard in protest.
Yeah, well, I don't blame them for being disappointed. I don't blame them for feeling like the system is stacked against them and that this is yet another result in this direction. I think this case is a little bit different. Daniel Penny was not a police officer. That makes it different than some of these other cases. And, at bottom, Nicole, I always say the jury has the final word. We left it to the good judgment of 12 jurors who obviously worked very, very hard and considered the evidence over a period of days to come to a result. And I may not personally agree with that result. In fact, I don't, but I have to acknowledge that the jurors get the final word here, and I have to respect their decision. There may be protests. This is a volatile issue. And I will say there's no way Jordan Neely should have died on the subway that day. That seems to me to be something that is worth more examination, worth more thought, worth some protest and some doing about. Because that doesn't seem to be something that had to happen.
And I know that law so much depends on what happened before. So my last question for you, do you think this case in any way will set some type of precedent moving forward?
Yeah, it's a little bit of a precedent, in a case like this, but these cases are always so fact specific. This is not a broad authorization of vigilantism. This isn't saying you can just go on a train and strangle anybody who bothers you. Anybody who thinks that that's what this verdict says is wrong. This is a very specific finding about a very specific set of facts. It's disheartening, surely, for the family of the victim, but I wouldn't say it is broad authority to go out and commit acts like this going forward.
Well, we certainly appreciate your input. Trial lawyer,